Good morning and welcome. Today's presentation for October 2025 is on the very old case of Condon ex parte James. I have to say I'm quite impressed by you lot, my audience. If you've been to a number of these, then you'll know that I do quite enjoy finding old and obscure topics rather than the latest hot topics to talk about. But I did think on this occasion, going back to ex parte James, over 150 years ago, I wasn't really sure how many people would be particularly interested in turning up for it. Well, I have to say, pat on the back to all of you. You are all, and I mean this very kindly, a bunch of absolute geeks, because there's, I think, over 100 of you likely to be participating in this. So anyway, I want to get on with this because, as always, I'm going to try and cover the topic in 30 minutes. And the story of ex parte James is actually quite a confusing and complex one. So I really need most of that time to try and track my way through it. So before I started preparing this presentation, I think probably everything I knew about ex parte James was summed up on this one slide. That it's something that I'm familiar with seeing as an argument of last resort. If somebody is aggrieved by what a liquidator or trustee in bankruptcy is doing, and they don't seem to have any other argument, then ex parte James always comes out there to demand that the trustee should either stop doing what they're doing or should do something that they're not doing. And something that they're not doing is frequently something like spending huge amounts of money on speculative litigation that will benefit nobody but this one particular creditor who really thinks they should be doing it. The general principle, I think, behind ex parte James is one of fairness in the way that office holders should behave, and in particular that you shouldn't be hanging on to money when it is unjust to do so. And I think I would probably sum up ex parte James as saying it's really a somewhat vague duty of honesty. It's a case that is more often than not deployed as an argument of last resort. And sometimes it is the only argument that is being deployed. And again, I have to say that generally speaking, when I've seen that, where the best and only argument that the other side have got is ex parte James, I've tended to think that they're on thin ice and that we're probably in quite a strong position. That's a bit of an oversimplification, I think. I want to start by going back to the case itself and just summarizing the facts, because I suspect it's something that very few of us will have ever needed to do. So for this, we're going to be going back in time to 1873, and amongst other things that happened at that time, John Condon's business in Millwall ran out of cash. I don't know what the business was, and I don't know what the trigger was for its failure, whether it was a business that had been struggling for some time, or whether it was just this one piece of litigation that knocked it out. But anyway, one particular creditor, a chap called Bradshaw, got judgment against Condon for £274, 3 shillings and 5 pence. And according to the Bank of England, that is about £27,000 in today's money. So it's a sensible amount. The creditor enforced by sending the sheriff in, by levying execution and seizing Condon's goods. And in response to that, Condon then filed a petition for liquidation by arrangement. If you'd like to ask any questions about how liquidation by arrangement works, I'll be happy to deal with them afterwards. It's a bit like an IVA, but I won't say any more about it now. In this particular case, it failed anyway. Upon its failure, the sheriff paid the value of the execution across to the creditor, to Bradshaw, and then another creditor petitioned to bankrupt Condon. And when James was appointed trustee of the bankrupt estate, he then demanded that the creditor should pay to him the money that he had received from levying execution. The creditor, Bradshaw, took advice before doing that, and on the basis of the advice that he was given, complied and handed across to the trustee the money that he had received from the execution. Then there was a new court ruling which effectively overturned the previous understanding about who had priority in a situation like that. Had this Court of Appeal decision in Villas come a bit sooner, then the advice that Bradshaw would have received would have been, hang on to the money, you don't have to pay it to the trustee. Accordingly, Bradshaw asked James to return the money to him, and James, in the manner that is consistent with trustees in bankruptcy regarding that possession is 9/10 of the law, said no. It went to court, and the court then ruled that the payment had been made under a mistake of law, but at that time that wasn't something that the courts could put right. Now that has changed in the intervening 150 years, but at the time money paid under a mistake of law did not have to be repaid. However, the court did feel that it was inequitable in the sense of it being really rather unfair for James to hang on to this money rather than returning it to Bradshaw, who legally would have had the better right to it if the law had been better understood at the time. And the court, in making this ruling, made a number of statements which have then formed the basis of the rule in Ex parte James since then. Firstly, the key point here is that a trustee in bankruptcy is an officer of the court. And the court then went on to say that a trustee in bankruptcy, finding that they have money which in equity belongs to someone else, and here I'll just digress by saying that where the court said that the money in equity belonged to someone else, they were using the word equity in a different sense to how I would expect the court to use it now. Now, if a court said in equity the money belongs to someone else, they'd be saying that other person is the beneficial owner of the money. In this particular case, that's not what the court was saying. The court was saying that simply in fairness, that money should not be kept by James, by the trustee. So they're saying that in a case like that, the trustee should set an example to the world by paying the money to the person who is really entitled to it. In my opinion, the Court of Bankruptcy ought to be as honest as other people. And of course, this is a little problematical because if a trustee in bankruptcy is supposed to be as honest as other people, well, which other people in particular? It does seem to impose a higher standard on insolvency practitioners than the rest of the world. The courts expect everybody to comply with the law, but it seems that insolvency practitioners are not able to enforce their full legal rights when that would be inequitable, whatever that might mean, because we're in the realm here of subjective value decisions about integrity and honesty rather than looking at clear rules of law. So that was the ruling in 1874. And let's have a look at what happened next and how the cases developed. I mean, they could have just faded into irrelevance, but it did actually develop something of a new life of its own. And there are two cases, Gosset in 1936 and Clark in 1975, which are important milestones in how Ex parte James developed. So the first one we'll look at is Gosset, this 1936 case. You'll be able to have a look at these slides afterwards. I'm not going to go through the facts in any great detail, except that what we had here is a creditor who was claiming to rely on Ex parte James to try and improve their position in a bankruptcy. And they referred to these three other cases, Tyler and Hall, both of 1907, and Thelleson of 1919, all of which had been similar to James and had developed James, and which had actually between them left the law in a complete mess. And In this particular case, the court said from those cases it is difficult to derive and explain any specific principle at all. And what they then did is they took the opportunity to distill those cases and ex parte James into two basic principles. The first one was that the court could rule against the office holder where the office holder had received money by mistake. And secondly, the court might well do so if the office holder would be doing something dishonourable by acting in strict accordance with their legal rights. So it's those two aspects that the court felt could give somebody a remedy, is if there had been payment of money to an office holder by mistake, plus dishonourable conduct by the office holder in then continuing to hold on to that money. And that effectively redefined James until the Clark case in 1975, where the courts looked at it again. And this was a bankruptcy of a service station in London, where the proprietor had gone bankrupt. And in 1969, which is when the bankruptcy happened, it was the 1914 Bankruptcy Act, and you had this interim phase in a bankruptcy where the court would make a receiving order. And the receiving order would be gazetted, and from the date of the receiving order, all property dispositions by the bankrupt would be void, similar to the arrangement that you currently have with a winding up petition in section 127. And what happened in this particular case is that there was a printer's strike at the time, which meant that when the receiving order was made, it was not gazetted until 2 weeks later, which meant that nobody knew that the receiving order had been made, and it meant that the bank did not know that they should freeze the bank account. As a result of this, for 2 weeks after the receiving order was in force, Texaco kept on delivering petrol to the petrol station, and the owner of it kept paying for that petrol by writing checks, which the bank then allowed to clear. And the petrol was then being sold, money was coming into the bankrupt's bank account, being used to pay other creditors, and actually was contributing to building a useful credit balance in the bank account by the time the bankruptcy order was made. When the trustee was appointed, the trustee said, well, that's all very well, but the two checks that Texaco received and which cleared were both void. That's the effect of the law. That's what happens when a receiving order has been made. Those checks were void. Texaco, you've got to pay the money back. Texaco objected on the basis of ex parte James, saying that the estate had actually benefited from the value of the petrol that Texaco had delivered. And the court agreed there with Texaco, and they did not allow the trustee to continue with the action to reclaim the value of the void checks from Texaco. And in its ruling, the court then set out 4 principles of ex parte James and when the rule in ex parte James would apply. The first one was that there had to be a degree of enrichment of the estate by the aggrieved party, by the party that's looking to rely upon James. Second one is the aggrieved party must be unable to prove in the bankruptcy. I have to say I have some difficulty with that one because I don't really understand it in the context of the Clark case, but let's skip over that for now. The third one, which is the most important one, is the honest man test, which is the question of whether an honest person would say, it's actually not fair that I should keep the money. My claim to keeping this money is without merit. And then the fourth one is a limitation on ex parte James to say that when the rule does apply, it can be used to nullify the estate's enrichment, but it won't go further than that. It will not put the aggrieved party back in their starting position. And there's a case I'm going to mention in a minute or two that illustrates that point quite nicely. But the crucial point here is the honest man test. And this again is part of the problems with ex parte, James, that this is really rather vague and imprecise, and it's very, very difficult for a trustee in bankruptcy or a liquidator or their legal advisor to know in advance whether what you're doing is within or outside the scope of that honest person test or not. Sometimes it's very, very obvious, usually it's not. So those are the two cases which are the sort of milestones in the development of Clark. What's happened since then? What's the current rule? Well, there have been a number of changes since 1874, as I said when I was summarising the effect of ex parte James itself. If money has been paid under a mistake of law, it can now be claimed back. In 1874, the law was different and it was not possible to claim that back. The Bankruptcy Act 1869, of course, has now been long repealed. And something else that is clear is that the rule in ex parte James does not apply only to trustees in bankruptcy. It also applies to compulsory liquidators. It also applies to administrators who've also got their own statutory restatement of something similar to ex parte James in, I think it's paragraph 73 of Schedule B1. It may or it may or may not apply to voluntary liquidators. There have been a couple of cases about ex parte James and voluntary liquidations, and the decisions have not been consistent, shall we say. I think probably the best interpretation currently is that it probably does apply to voluntary liquidators as well as compulsory liquidators, but we're not entirely sure. It also applies to public bodies such as government departments, councils and the like, who have also got this general duty to behave honestly and not to hang on to money when it would be inequitable to do so. We've also had a small, relatively recent burst of cases about ex parte James, particularly in 2017 for some reason, but with more in 2020 and 2021. I haven't seen any that have been more recent than that, but you never know, that there could be one at any time. So these are the cases that I want to refer to now as being the most modern examples of how ex parte James seems to work these days. The first of those is Young in 2017, and this was, the context behind this was a divorce, a lot of money involved, big financial claims. Mr. Young failed to comply with his obligations under the divorce settlement. He became bankrupt and then died suddenly. Mrs. Young was the beneficiary of 20% of a life policy, and the value of her interest in that policy was probably somewhat over £250,000. The trustee in bankruptcy set up a meeting with Mrs. Young, at which she persuaded her to give up her 20% in the life policy in return for a payment from the estate of £15,000. But when the trustee then sent Mrs. Young an agreement to sign, she had second thoughts about it and refused to do so. The trustee in bankruptcy said, "We've already got a binding agreement. You have to comply with it. You have to perform your side of it." The court didn't like this. They were particularly worried that this was a bad deal for Mrs. Young and that she had not had the benefit of independent advice when she made the agreement. The court felt that in those circumstances it would be wrong for the trustee to enforce her contractual rights on the basis of ex parte James. And this is one of the, I think, the modern practical points pull out of ex parte James, and which is definitely relevant to today's practice, which is that I think office holders have to be mindful of situations where third parties should get independent advice, and trustees should do their best to make sure that they get independent advice. Second one, Heber and Duckworth, is in many ways very similar. The company was in liquidation. The liquidator had claims for unlawful dividends against Mr. and Mrs. Heber. They agreed a settlement in which Mr. Heber represented both himself and his wife, and Mrs. Heber was liable for £12,000 under it. Mrs. Heber objected, and she brought up allegations of duress or undue influence. And again, the court felt that in the context of that, ex parte James should render it unfair for the liquidator to enforce the agreement against Mrs. Heber. So again, another example of the importance of ensuring that there is independent advice. Third one is Evans and Carter. And this is quite an interesting case, I think, in terms of the facts. Mrs. Carter was fighting off repossession by her mortgage lender, and she went bankrupt in the course of the battle. But eventually she did win against the mortgage lender, and the mortgage that she had signed was set aside on the basis of undue influence. She hadn't been properly independently advised at the time when she signed the mortgage deed. Now, as far as the trustee was concerned, this was very good news, because now suddenly there was an awful lot more equity in the property than there had been before. Mrs. Carter objected to the trustee being able to repossess the property and realise that equity for the benefit of the estate, saying that wasn't what she had fought the mortgage lender for. She sort of won on this. She was granted relief under ex parte James, but the court said this would not take the equity out of the bankruptcy. The court said it would be unfair for the trustee to keep all of the windfall that they had received, all of the value of the equity, given the amount of money that Mrs. Carter had spent in fighting for it in her battle against the mortgage lender. So the trustee was ordered to reimburse to Mrs. Carter the legal expenses that she had incurred in fighting the mortgage lender, but the rest of the equity in the property still belonged to the trustee for the purposes of the bankruptcy. So it was a bit of a Pyrrhic victory for Mrs. Carter in all of this. We've then got the two more recent cases, which are not involving issues of undue influence or the like. First of those is Lehman Brothers. And there are lots and lots of Lehman Brothers cases in the reports, of course. This particular one is Lehman Brothers Australia and McNamara. As you'd expect with a Lehman Brothers case, it's long and complicated, but I hope I'm not oversimplifying things, where I say essentially what this boils down to is that both sides made an error in calculating a settlement figure. As a result, the wrong figure went into a settlement agreement that both sides signed and intended to be bound by. When the mistake was realized, ex parte James did allow the other side to ask for that agreement to be corrected, despite the fact it was already a binding agreement and the courts would not normally reopen a binding settlement of that sort. The last of those cases is HMRC and Sanders, 2021. And this is one where HMRC were by far and away the biggest creditor in a bankruptcy. and the trustee, having taken careful legal advice from tax counsel, decided to reject HMRC's proof of debt. And there's no doubt that this was a legitimate and technically correct decision to take, but it was very much on a technicality. And HMRC appealed the decision to refuse to reject their proof of debt. The court allowed HMRC's appeal, primarily on the reason for the decision was tax legislation allowed them to do this. But they also added to this the application of ex parte James to say, in effect, it was simply not fair for the trustee in a case like this to rely purely on a technicality to reject a proof of debt. And the court noted that the counsel had not actually been asked to advise on ex parte James when reviewing and advising upon whether the trustee should be accepting or rejecting the proof of debt from HMRC. So those are, in fact, the recent examples of when ex parte James has been used, has succeeded, has applied, which just go to show that it's not a completely worthless argument all the time. There are situations when ex parte James can be very important and can actually be decisive. So we now get to the point where these are the summary slides. I'll try and pull all of this together and try and make some sense of what we've been looking at. So the first one is ex parte James as normally encountered. How we normally see it is a letter from solicitors, usually expressing intense disappointment and surprise at the actions of an office holder, usually a very long moan, followed by a demand that you either desist immediately from doing something or you intervene immediately and start doing something, with the reason for this, the justification being given as ex parte James. And the question, of course, is exactly what is the rule in ex parte James? And I think one of the things that I have discovered in my meander through all of the cases is it is actually a little bit vague and a bit imprecise and very, very hard to pin down exactly what it means. The original rationale, the bases for the decision in 1874 no longer stand. In ex parte James was really just trying to do justice in a case where the law was unable to correct a mistake of law, which the courts can now do. And of course, the problem was created by some poor drafting of the Bankruptcy Act 1869, which again has now long since been repealed. One of the, I think, points that seems to come out of ex parte James is that the rule should do no more than nullify the estate's enrichment. And we saw a good example of that in Evans and Carter, where winning under ex parte James did not give Mrs. Carter the full value of the equity in her property. It instead only gave her reimbursement for the legal expenses that she had incurred in her long battle with the mortgage lender. One of the key takeaways from all of this, I think, is the importance of making sure that spouses get independent advice. Third parties generally, if you're making an agreement with them, it can be very important to make sure they have independent advice. The Lehman Brothers case, I think, suggests that you should take it very seriously if the ex parte James argument is based upon a mistake that the other side has made or that both of you have made, which has given a benefit to you. That's a situation when you might find that ex parte James does actually have some teeth. And the final point I want to make is that the honesty point in ex parte James is critical. It's very vague, it's very imprecise, but nevertheless, it is a common thread through all of these decisions, this idea that it is unfair, almost dishonest of the trustee to enforce their strict legal rights in all of these situations. And considering that we've got a new insolvency code of ethics that took effect less than 2 weeks ago, I'm just wondering if at some point someone in the future might link obligations under the insolvency code of ethics to ex parte James and say that if you're falling short under the insolvency code of ethics, that might be more likely to trigger a legal claim under ex parte James. So with that, and my apologies for dashing over some of the slides a little bit quickly, but they will all be in the handouts. That's the end of the half an hour on ex parte James. I hope you found it useful. I hope you found it fun as well. If you've got any questions, please do ask them now. I don't think I've got any so far. And so on that note, I say thank you very much, and I will see you again in November for the next in our series of coffee break briefings. Thank you very much.